Are we today?
37.
Day 37. So we've got just over a week left. So welcome everyone here. And I don't know if we want to start with any questions from our online visitors.
We don't have any yet.
Okay, well, we'll wait for them and we'll open it up to non-toll road questions from the press, okay?
I don't think it works that way.
It doesn't work that way? That's a restriction on the freedom of the press, is what you're telling me? Freedom of speech.
So you were here late last night. What's the plan going forward as far as nights? Are you days the rest of the week?
We'll be meeting again as a joint leadership, I think tonight at 6. So we're just working on bills as they come off the board. We moved quite a few bills yesterday, didn't we?
Quite a few.
I think it seemed to me there were 15 Senate bills left on our board is all, but more will come on as we go through the committee process this week, but we seem to be moving through fairly expeditiously.
So is that no more late nights or at this point, or?
Usually on the Monday of the last week, we try to move all the Senate bills off of the board. So Monday may be a late night depending on how many bills are left on. So you'll know probably Friday as you see the number of bills that are left there. So President, right here in the middle, we saved this for you.
No,
So we've opened this up to non-toll road questions. So we've
just passed the house.
But we would like you in the hot seat.
okay.
That's where the camera's on.
What does the Senate Republican caucus want to do about the new bylaw that has?
I thought we were talking about toll roads.
No, that's not.
Oh, okay. So go ahead, Bob.
The new bylaw that is, everybody seems to say is illegal. What does the Senate Republican caucus want to do about it?
Which bylaw?
The Central Committee bylaw, which
Oh.
was passed in the special meeting, that apparently breaks, no longer has the Republican Party being a qualified political party.
Well, I don't know what we're going to do about it because we don't know all the ramifications. There's been some talk about passing a bill that will, in the event that this kind of blows up, will allow people to get on the ballot because that could be part of the problem. And so I believe that we'll need to at least address that to prevent, a litany of lawsuits and so forth. Because if people couldn't get on the ballot under the Republican, with the Republican name or the Republican brand, that would be a huge problem. I think there would be all kinds of lawsuits. So I think that there may be legislation to fix that.
Isn't that already law though, that they can get on the ballot?
Well,
So why would
but
bill need
if
to-
you're an RPP, and I couldn't address this like Senator Bramble could, that's a discussion we need to have. Let's get Senator Bramble in here. But if the Republican Party gets disqualified as a QPP, then you're an RPP. And what if you didn't sign up to collect signatures? And what if they're disqualified some other way? There's a couple of scenarios that I really can't address as intelligent as Senator Bramble can. And so we'd need to probably address some legislation to fix that.
And what would that look like, that legislation?
I'm going to defer to Senator Bramble. If we want to have that discussion tomorrow, I'll have him come in.
My understanding is one of the ways is to say candidates would be running under the rules in place as of a date previous to this change. And that would be across the board for all
Unless somebody
parties.
is familiar with that, I think it would be best for Bramble to address it.
Might be a good thing for Democrats. Being the only party on there. That allows them to fix it quickly.
We might get 6 out of 29 instead of 5 out of 29 this year. That's it.
Can you tell me which one's more of them?
I am.
This would be the time to be out, right?
That's right. Total.
Can we talk about the toll road Bill, President.
Sure.
I understand it was
I can
substituted
talk about that
over
one.
there? There you go. It was substituted, what did you do differently over there?
In the substitute, there is a provision for, like, there's two provisions. One is where there's some more study. I'm trying to remember how the amendment reads. And the other, it'll give some study time and some clarity on there being some process in implementing a road. And then the other part of the amendment is to address car rentals, where at least for now, maybe a transponder would be the best way for that to happen versus, you know, a photographic type of tolling.
License plate.
Which is license plate. Or there, you know, photographic type of tolling could be a lot of things in the future.
Well, why is transponder better? I mean, if you've got a reader, wouldn't they just read the plate of a rental car? And
Yeah, what this does is allow some study and some work in the substitute to kind of determine what we're going to do with rental cars and how they're going to be tolled.
And is it just rental cars that it deals with?
Yes.
And does this delay the implementation of this at all? I know.
No.
When would we expect to see some of these roads in place?
Well, I think several years from now. I think at least 2 years, maybe even more. But what we need to have is the policy in place, because UDOT plans roads 10 years, 20 years ahead, and having that policy in place will help them in planning on how, one, we're going to pay for the roads, and two, we already have tolling. It's going to be part of our future, and how that tolling can happen.
And I mean, right now, we have toll roads in place. The express lanes, wouldn't it be nicer than having to buy a transponder? You just pop into the express lane and pay the toll, and then pop out of it. And I think that is how. I mean, right now you have to have a transponder if you're not, if you don't have high occupancy in your car. If you have 2 or more, you can run in that lane anyway. But if you're a single person, you buy a transponder, get in the lane, and pay the $1 or $2 fee. According to President Niederhauser's bill, you may not need a transponder. You get in the lane and read your license plate. And so that is so much more seamless and so much more open to everyone, and broadens the capacity and the simplicity of it. So when you say toll roads, I think we have this all are fixated on this old process. It's basically vehicle miles traveled and choosing what road you want to get on and how far you want to go.
But don't the transponders, at least in the HOV lanes, don't they serve to control the number of people in those lanes so they continue to be valuable? Because anyone can just pop in and out and pay.
The transponder doesn't control it, the price controls it. So when they raise the price up, that will control, hopefully, that congestion pricing. So if you raise that price to $4 or $5, then less people are going to go into it. When there's not a lot of traffic, it may be a quarter. When it's very congested, and the congestion pricing model is to have the price reflect 55 or 65 mile an hour speed, and that's what allows those lanes to be so valuable.
But I thought that that's why there was a limit on access for single drivers, is to make sure that the HOV lanes weren't overcrowded. So you're saying the prices could end up going up?
There's so many possibilities when
Yeah.
you have electronic tolling, because it's technology.
And
I can think of several scenarios right now as far as the HOV lane is concerned.
so
If one is, we see a lot of people going in and out of it illegally. They would identify those folks, you know.
Some scofflaws too, putting a little more burden on law enforcement.
as well.
Yeah.
Well, I don't know if it's, wouldn't really burden them, it's actually lessen their burden
Just
because
electronically
you electronically, you've been in the lane and you didn't pay for it type thing. These are possibilities we're just throwing out with technology and electronic tolling, and it may be 2 lanes. It may be all the lanes at some point, and it will be congestion pricing. Based on, to try and incentivize people to use the road, not in traditional drive time. These are all possibilities that will be addressed. This just is an enabling legislation.
And what about the area that you had raised, that brought this concern to you, Little Cottonwood Canyon? You said maybe 2 years. Does that include the canyon, or would you like to see that happen sooner, now that you have it once this bill passes?
I think it will be in conjunction with the reconstruction of the road. So there'll be an additional lane going up Little Cottonwood Canyons. Probably the construction will start in 2020. And the tolling, I think tolling, there's a high probability that tolling will be part of the solution there to get people out of their, to incentivize people not to be a lone person going up in a car. There's 70% of the cars that go up now just have one person in it. Through electronic tolling, we can incentivize people to carpool and to take a bus. So. Senator Bramble's here and can answer questions about some of the potential election problems.
So what you gonna do?
Well, that's a $64 question. I think it's clear that when we wrote Senate Bill 54 and we created the qualified party path, we never anticipated that a political party that made an election to be treated as a qualified political party would, subsequent to making that election had to be made in September of the odd-numbered year before a general election. We never anticipated that a political party that makes that affirmative written election to be treated as a qualified political party would then intentionally change the party's governing documents to violate or to disqualify the party from having that status. And the reason for that, the qualified political party status is the only way that a political party can have its convention candidates, the candidates that win in the convention, move to the primary or general election ballot. Primary in the case of more than one candidate, general election if they win the convention and there's no other members within their party that are challenging them either through signature or in the case of convention, over to come out of convention. So we never anticipated that, and so there's a gap in the law because the law is silent. What happens if a party qualifies at the time they file and then subsequently through changing their governing documents becomes disqualified? There's no provision in the statute, and so what are we going to do? We're going to attempt to close that loophole. We believe that it's appropriate for the legislature to create election laws rather than leaving it to a court.
So what's the remedy then in your mind? Would that mean that in this case with the Utah GOP amending its bylaws, do they become an RPP by default? That means no caucus convention system for them at all?
In the absence of doing anything, the most likely outcome would be that the party could be, if someone files a lawsuit claiming that, maintaining that the party should be disqualified. If you look at the timing on that, there's been a lot of speculation, well then, those individuals would run as unaffiliated. If you look at the law, the problem with running as unaffiliated, they basically would end up being write-in candidates, just because of the timing on filing deadlines. So we're looking at giving the lieutenant governor the statutory authority to make a determination if a party disqualifies itself as a qualified party. We're looking at the timelines and what do you do with candidates that have already filed for or begun collecting signatures, and there's some challenges in making certain that that every individual, every citizen who wants to run for office understands what the pathway and the procedures are for them to do that. That's the primary objective, is the sanctity of the ballot and those individuals that want to put their name forward, and how we accommodate that so that there's a certainty in the election path. So
See,
what we're
here's-
gonna do, that's what we're trying to do.
And Senator Bramble can correct me, but here, one of the problems that I saw was, what if you decided not to collect signatures now? Let's say I'm up for election, and I have signed up to collect signatures, but what if I decided that I wasn't gonna collect signatures? What happens to me if my party's disqualified?
Well, there's a difference between.
Because how do I get on the ballot?
Well, that's what we're trying to address. And so from qualified party, where the party's candidates go on the ballot, to unaffiliated in the event of being challenged, the most likely solution, and we're working through all the legal challenges right now, seeing if we can find a statutory solution, would be that if an event triggers the disqualification of a qualified political party, that they would revert back to a registered political party, in which case the signatures for a registered political party is 2% of the registered party members within a district. So for an average House seat, it's going to be in the 100, mid-hundreds, 150, 200. For a Senate seat, that ranges from there up to about 500 signatures. So it's a much different threshold. So in the case of wanting to go to the ballot, thinking you're going to go through convention, now it's an RPP, way to get on the ballot is through signatures. We're looking at the time frame for when you would have to get those signatures. The signature threshold is much lower, but there still needs to be a reasonable time. And we're recognizing that in virtually every court decision, the default for the courts is to be very liberal in construing election law in terms of candidate access to the ballot. We've seen that with school boards. We've seen that when a candidate doesn't file their financial disclosures and they go to court and the court puts them on the ballot. So we're sensitive to the notion that the courts would likely rule in favor of candidates being on the ballot, not excluding candidates.
But it also essentially means that the party that wants or the faction of the GOP that wants a caucus convention system, as a result, loses the caucus convention system entirely.
That is a very likely outcome as a result of their actions on Saturday.
One of the things I've heard, Senator Bramble, is that there might be a way to have the rules that were in place when people signed up to gather signatures apply.
I hear a voice.
Yes. Hi, sorry.
The chair-
You're sitting in the back of the head seat, a
Okay.
chair.
Do I have a bald
Sorry.
spot? Is it covered?
Get on the House floor and we can tell you.
The difficulty with that, so that was one of the things we considered, basically freezing the bylaw, saying, okay, whatever was in place at the time the election for QPP was made, that freezes it. And then someone files suit, maybe another political party potentially could file suit. I don't know who that might be, but assuming there was another political party that might file suit, that throws that uncertainty right back into play, because now it's not the Republican Party controlling, and it's not the lieutenant governor, but rather the courts. And if you disqualify yourself from QPP, it leaves the threat of litigation for the courts to determine that you're disqualified. We believe the safer path would be to, if there's a default, to have lieutenant governor have the authority to declare that the party has disqualified under QPP and remains a registered political party.
What about those candidates that signed up to gather signatures under the law, under a QPP with certain bylaws in place, and then?
Those signatures would have to convert to registered political party signatures.
But why can't the argument be made that when they signed up to gather signatures as candidates, and in effect declaring a candidacy in a way, that the rules that were in place then need to stay in place?
You can make that argument. Keep in mind, the notice of intent to gather signatures is not filing for office. We have no candidates until The filing period opens on March 9th through the 16th.
So there is another, one other scenario that I think is, that I'm a little bit sketchy on is, let's say I don't want to collect signatures. And I'm still adamant about not collecting signatures. And in 2 weeks, you know, we passed this, we're trying to correct this, but if we did nothing and somehow the party was disqualified, now I'm faced with, if I'm running for office, who didn't want to collect signatures, having to collect signatures even though they're 2%, in a probably a very short period of time. And so are we going to address the length of time that we would now allow those folks to do that?
That is one of the considerations. But
Yes.
keep in mind, the whole objective of an election is for citizens that choose to run for office have a pathway that they can rely on. And so we're trying to do no harm to any candidate, recognizing that we never anticipated the actions of a faction within the Republican Party that is intentionally trying to get the party disqualified.
Well, as I understand it though, that rule doesn't even take full effect for the party until convention. Is that what you had said, Senator Van Tassel?
Well, I'm still learning. I think I did make that reference, but I'm not sure.
You're not the first person to say that. Is Senator Bramble, do you know for sure what the situation is there, or is that in dispute as well, when that action by the Central Committee actually becomes?
Okay, there's an intersection between the political parties and the statutes controlling the ballot, but beyond that, it's not up to the state to determine the internal workings of a political party. And so that raises another concern. What is the timing, and when does this all have to be identified? And that's what we're working through right now. We don't have all the answers today.
But you could still take action and have it take place contingent on that rule being, if that were the case, right?
Let me go back. The issue is what happens if a qualified political party disqualifies itself through its own actions. What happens to the candidates of that party? Do they become, is the party simply off the ballot? Does the lieutenant governor have the authority to rule that the election to be a qualified party is no longer valid and the default is registered political party? That's what we're working through right now.
Maybe we'll be dealing with 75 Democrats in the House and 15 Democrats here in the Senate.
So you're amending your statement.
Under that scenario.
I might have been right.
I'm here a second.
All right, so that's all the questions that we have time for today. Any questions from our viewers?
We do have one from a viewer. This viewer asked, what have you done to advance women in the state this year?
Okay, well, a couple things. We did recognize Martha Hughes Canyon, and now her statue will be in the hall of, where is that at in Washington DC?
Capitol Hall.
Statuary Hall.
Statuary Hall. So that's been done. We are recognizing through, probably with an appropriation, that hasn't been decided quite yet, but I think it will be decided, to support a organization called Better Days, which is a celebration of women's right to vote in 2020.
We funded a program down in Utah County that is bringing women into math and science.
Yes, we did
We've
fund
set
that
some money
also.
aside for that.
And there's probably many other things, so thanks for that question.
I think Senator Escamilla's study, a wage study issue, which will deal in that area as well, may be a study item that's added on to the studies during the interim.
There's another area that we've done a lot of work on, and that's in the domestic violence arena. There's a bill coming over from the House Bill, I think it's 333, but those primarily affect women in our state as victims of domestic violence.
You've got a breast cancer bill too, maybe runs along.
Well, we have a breast cancer bill dealing with screening for breast cancer and dense tissue, requiring better notification.
And there's been a lot of funding for domestic violence shelters. A little bit.
Thank you for that question, and we'll conclude our availability today, but to look forward to seeing everybody tomorrow.
Thanks, Senator.